but the combination of education, industrialization, and innovation led them to become the 13th largest economy of the world by nominal GDP in 2025. Just to mention some of their accomplishments, is the largest manufacturer of semiconductors, chips, and screens. Is the second largest manufacturers of ships and mobile phones. The 6th largest manufacturers of cars, they particularly manufactures Kia and Hyundai cars, which are sold all over the world. And basically, they export more than $700 billion. So I think it's the 7th exporting country in the world. Just a small country without nothing, but through education, through innovation, and very strong work, they became a very powerful country. In terms of IP, they have a strong IP system, and the patent office is one of the best of the world. Just to give you a number, they filed 250,000 patent applications per year. We can compare in Argentina, I think we are filing 4,000 patent applications per year. We used to have better times up to 8,000, but nowadays I think we are in 4,000. Brazil, which is an important country in Latin America, they received 25,000, 30,000, but 250,000. Of course, we have China, 1,500,000 patent applications per year, but South Korea is amazing. Well, another example of the relevance of the combination of innovation and the protection of intellectual property is if we take the ranking of the 10 largest companies by market capitalization. 10, 15, 20 years ago, you can find within the 10 best companies like Walmart, ExxonMobil, Chevron. Nowadays, if you look at the rankings, I took one ranking the other day through AI and internet. Most of the companies are technological-based companies. Just to mention Apple, Microsoft, NVIDIA, Amazon, Alphabet, Meta, Tesla, and so on. The 2 other companies are the sole exception. One is Saudi Aramco, and the other one is Berkshire Hathaway. Then we have other ways to check the innovation. There is the World Intellectual Property Organization, WIPO. WIPO is the United Nations agency specialized in IP, who administer and manage and do all the cooperation regarding intellectual property all over the world. They administer most of the treaties, but they publish a Global Innovation Index, GII, annually. If you look at the 2024 report, indicate that Switzerland is the most innovative economy for 14 consecutive years, followed by Sweden, the US, Singapore. As you can see, there are some of them, of course the US is there, but some of them are very small countries with, of course, not natural resources. I mean, Switzerland has a beautiful landscape, but they don't have oil, they don't have gas. The same equation applies to these countries. But also we can see who are the fastest climbers in the ranking, and you can find countries like China, Turkey, India, Vietnam, and the Philippines. Vietnam and the Philippines, and I stress the fact of those countries because these are small countries. So, to conclude and summing up this first part of the presentation, I think we can conclude that without innovation and a strong IP protection system, a country has no future in a modern economy. And this leads to the second part of the presentation. We are going to analyze how strong IP is in Argentina, how well protected are in Argentina the IP rights. We can summarize and say, as an introduction, that in our country, IP rights have a reasonable protection, but of course need a lot of improvement. We have, in order to analyze the legal framework, which will be the first approach, we have, of course, the national constitution. Below, we have international treaties, which, by the way, according to our national constitution, international treaties prevail over federal and local laws, and of course, regulation and resolutions. So we have this. We have signed many treaties, Paris Convention, Berne Convention. These treaties are administered by WIPO, but the most relevant treaty on IP is the World Trade Organization and the TRIPS Agreement. The TRIPS Agreement is an agreement on trade-related aspects of intellectual property rights, was signed in January 1995 by more than 160 countries of the world. And it's a very interesting case because it was the first time that intellectual property was included in a trade agreement. If you remember all the negotiations that started mid of the 20th century with the GATT, the traditional GATT, which were negotiations for reducing the tariff between countries, that led until the 90s, and in the final round, the Uruguay round, was signed finally this important treaty to bring a lot of oxygen to the economy of the world and improve the life of so many people through globalization. And in this treaty, they include intellectual property. We are members of the World Trade Organization and the TRIPS Agreement. And the TRIPS Agreement provides a basic minimum standards for protection for all kinds of intellectual property: trademarks, patents, industrial designs, geographical indications. It also provides a mechanism for enforcement, requires that the country has an enforcement system in place, preliminary injunctions, and also provides for the settlement of dispute between the countries. Well, so we have a reasonable patent law. In fact, we have a long tradition protecting intellectual property rights in Argentina. The first patent law was enacted in 1864. It was a very old law. That time was reasonable, but it didn't protect pharmaceutical products, only protects the process to obtain a pharmaceutical product. The patent application was not published at that time. It was an old law. So after enacting TRIPS, in 1996, Argentina was obliged to modify and modernize its patent law. And we did it. We have a good patent law with the same characteristic of any of the patent laws, France, the US, Brazil. I mean, its public application is filed, they check the formalities, it's published 18 months later, and then there is the substantive examination, the possibility to raise objections. Our system doesn't have an opposition system, other has, and then the granting or rejecting of the application and the possibility of appeal. Everything was fine with our patent law, but the only thing is we talk about pharmaceutical products, and we had included in the new patent law in 1996, pharmaceutical products. But in 2012, Argentina, specifically the Patent and Trademark Office and the Ministry of Health, issued a resolution, a joint resolution, giving certain guidelines for the examination of pharmaceutical and biotechnological patent application, and excluding from protection many pharmaceutical products. The level of protection in Argentina for pharmaceutical and biotechnology products is very limited. We can only compare with Venezuela. If we compare with the neighboring countries, Chile, Brazil, Colombia, Peru, is quite different. So, because of that, another lack of protection in other areas because of a lot of anti-counterfeiting activities and faking products being sold in a fair called La Salada, which sold an enormous amount of fake products. Argentina has been included in the Special 301 report, which is released annually by the US Trade Representative, basically identifies countries with inadequate intellectual property protection, which of course can impact the US business. In that case, can impact European business, US business, Brazilian business, any country, any company that has a real intellectual property in his portfolio. Well, simultaneously, we had signed a trade investment framework agreement, TIFA, which is a non-binding agreement with Argentina and the US. We promote trade and negotiations and dialogue. And within this framework, Argentina and the US are negotiating the reduction of tariff and as well as discussing intellectual property protection on pharma products, as well as the possibility of joining PCT. I will talk later a little bit about PCT. Moreover, Mercosur, of which Argentina is member, has signed a free trade agreement with the European Union. Said agreement also provides obligations regarding IP protection. The best efforts to become members of PCT, the Madrid Protocol, and the Hague System, which are 3 international treaties related to patent, trademarks, and design. So there are some ways to neutralize the inconsistency of IP protection in Argentina, and there is some hope that through this negotiation and through the signing and ratification of new trade agreements, we will be forced to improve our IP protection. But still, that is still an outstanding issue is the signing of the Patent Cooperation Treaty, or PCT. The PCT is an international treaty which provides a very simplified way to protect a patent application up to 160 countries in one single form, just designating, clicking the countries you want to protect, very economically. And unfortunately, Argentina is not a member. It's not a member for any reasons. Just to give you an idea, in Latin America, only Bolivia, Paraguay, and Argentina are not members. Uruguay are members. The thing is, not being a member of PCT not only affects our own researchers startup because they need to file national patent application in each country. If we mention the economically what means PCT, you can find one patent application up to 160 countries with 5,000, 10,000 US dollars. On the contrary, if you go national, country by country, you have to calculate 2,000, 3,000 like a country like Japan or the US. And if you count 20 or 40 countries, you are already in $50,000. For a startup or someone that is researching without capital, is a very anti-competitive disadvantage that has against any startup in Brazil, Mexico, or Chile that provides the possibility of using PCT. But also affect the foreign investors, because many times I receive a consult in the office asking, I want to file this PCT national face in Argentina. And I will need to say, no, there is not, we are not members of PCT, so it's not possible. And then I ask again, is that patent application already published in the PCT Gazette? Yes. Well, so there is no chance to protect, not even through the national phase. Because remember that patents need to fulfill with the novelty and inventive step required. Novelty is novelty all over the world. Anything that has been communicated in oral or written to the public destroy the novelty required. And also anyone who was researching the same invention in any country, Peru, Korea, before your invention, you are also lose the novelty required. So for what has been said, Argentina needs to reconsider the level of protection of IP rights. I can talk a lot about that, but I think it's not necessary. How it's functioning? Every country has a patent and trademark office. Argentina has one in place. It's an office composed by 350 employees. Used to be a very good office. They have very good authorities nowadays, but they lack resources. I mean, they need, there is a great need for infrastructure reforms, hiring more trademark examiners, patent examiners. Trademark and patent examiners are expert lawyers, expert engineers. It's not easy to get them. You have to pay a good salary, and none of them is possible with the budget the Patent and Trademark Office has. Just to give you an idea, in trademarks, Argentina received, the Patent and Trademark Office received approximately 120,000 new applications and renewals. You can imagine the backlog that means with this lack of personnel and expert to analyze this trademark application. And so they are making the best efforts, but not enough to cope with the backlog. Well, what's going on with the enforcement system? Well, first, we don't have specialized IP courts. We have federal courts for civil and commercial matters. They have been hearing IP cases, especially patent and trademarks and design, for more than 20 years. So they developed a certain expertise, but they don't have technical background. So in patent cases, they rely on the recommendation of the technical expert. In terms of injunction, you can get an injunction in 10 days for trademark cases, but not for patent cases, because when you claim that your patent is being infringed, you have to prove that your patent is not invalid. And that takes a lot of time, even up to 1 year. The regime in Argentina, the procedural regime is very complicated, written, very slow. So I would say that we are not up to the level TRIPS requires in terms of enforcement. Well, let's go to the last point, the most practical point, which is some recommendation for obtaining patent design and trademark protection in Argentina. The first thing I would recommend is be aware that you need a power of attorney. You need a power of attorney you have to give a power of attorney to a lawyer, a local lawyer, and the power of attorney has formalities to be valid in Argentina. Not only the signature of the grantor, but that signature has to be notarized by a notary public, and they provide it with the apostille, meaning that it can take 15 up to 1 month to get the power of attorney. So if you want to file immediately, urgently, it will be impossible. However, we have the possibility of filing the trademark or patent application as business representative, and then we will have 40 working days, which is almost 2 months, to get the power of attorney. So there is a possibility. If you file a trademark, perform a trademark search. So to avoid exactly or similar, confusingly similar trademark to yours, and avoid the loss of time for not being made a search. File the trademark application well before a year before you plan to start commercial activities in the country, because it will take 10 to 12 months to obtain a trademark application without opposition, and more than 1 year and a half in case the trademark meets an opposition. The opposition system is a little bit better now. It has been modernized and simplified, and now the trademark office decides on the merits of an opposition. Before, you have to go to a federal court, but this is something we cannot have time to talk about this. File for a specific goods or services. If there is a pre-approved list of goods or services, and if you file a specific goods pre-approved, you will avoid having an office action deleting your procedure. If you file this way and there is no opposition, you can even get a trademark registration in 6 months. So this is very important. Well, the trademark system doesn't oblige to use the trademark to the applicant when you file the trademark, but there are 3 different instances when you have to prove the use. When renewing the trademark, when someone challenges the use of your application, so a cancellation action, and also there is a need to file a declaration of use. Let's go to the patents, because we are getting to the time. Bear in mind that Argentina is not a member of PCT. I already explained that. So you can only file a national application and not rely in PCT. Remember, PCT allows you to wait until the 30 months to file national phase. In Argentina, it's not possible, and you have only 12 months. Well, be aware that it's a heavy restriction of pharmaceutical and biotechnological patent application, including the provision to protect second medical use. Timing for obtaining a patent is 4 or 5 years, a mechanical patent, and 8 years for a pharmaceutical patent. And regarding industrial design, the office doesn't check the substantive requirements. So it's only formal requirements about the name, the power of attorney, how the application was filed, and moreover, there's no need to file a special drawing in a special mode with formalities which used to be normal in the past. Now you can file a good picture or various pictures which can identify and describe the invention, sign, and that can be enough to support the protection. So, well, I will stop here, and I will be happy to answer any questions you have. Thank you for your attention.
Damaso, that was a great presentation. So I would like to thank you for being so clear about the innovation, how Argentina is handling this issue. And we have actually some quite interesting questions here, because you were mentioning a case from South Korea. So someone is asking, considering that Korea invested heavily in education and technology, what would be the most impactful areas for Argentina to prioritize in terms of human capital development?
It's a very good question. Of course, I am completely in favor of setting up a very strong ecosystem, IP ecosystem, very important framework. And in Argentina, I will definitely focus in the areas where we have more possibilities. Oil, gas, mining now is a boom. I mean, we have a system, an institution called CONICET, which was set up in 1958, where all the researchers are there. I will focus particularly in the areas where there are more possibilities to become a business, develop economic growth, and leave other areas like language or humanistic or political science or whatever to universities that they can afford that. But the focus will be in the main relevant areas of the economy for Argentina, which needs a lot of development.
Yeah, absolutely, absolutely agree. And here there is another interesting question from a company that says we often co-developed technology with local partners. How can we ensure IP ownership is clearly protected in Argentina in these collaborations?
Well, clearly you have to, the owner of the IP right has to protect the rights. Be aware that IP rights are territorial rights. So if you have a patent in the US, you need to protect in Argentina. Same with the trademark. So protect your trademark and your patent, and then clearly in a contract, you can license this technology to your partner or set any kind of agreement with them. It will be so what you are apporting to the company, but to be clear that this is your property and this is based on a title certificate issued by INPI in Argentina.
Yeah, absolutely. And we are past over the time, but there is another interesting question here that I didn't want to skip. And based, especially taking your expertise at the INPI, does INPI provide any kind of advisory services for international companies seeking to register or defend their IP?
Not exactly. What you can get in INPI is you can ask for a patent search where they can look at the technology, all the database they have with the technology. Argentina and other countries, I mean, they don't have the same technology means like the European Patent Office, the USPTO. So if you are looking for a very, very relevant search, I will recommend going to a private practitioner with a most modern database. But it is a good instrument, and you can get a response in 3 weeks, and it will be important information.
That's a great recommendation, a great tip. So with that, we will be wrapping up this session. Damaso, I would like again to thank you so much for being so clear and transparent about all these topics of high relevance. So thank you again, and hope to see you soon in another session.